Hi, everyone, and welcome to this month's Member Benefit webinar, The Newest Niche, Medicaid Planning for Immigrants. My name is Ashley, Education Events Coordinator at Elder Council. Thank you for joining us. Now it is my pleasure to introduce our presenter, Malini Mahadevan. Malini trained as a corporate lawyer in India before she took the bar in the United States. She represents companies and individuals in immigration, asset protection, and estate planning. She has been practicing since 2003 and is an adjunct professor at St. Louis University Law School in Missouri. She loves giving presentations and is so passionate about this subject. You all are in for a real treat. Thank you for being here, Nalini. The floor is all yours.
Oh, thank you, Ashley. That is so nice of you to say that. Hi, everybody. I'm Nalini Mahadevan, and my practice is about immigration law and elder law. And I have, in the course of my practice, tried to meld the two between. And and so our agenda today, we want to talk about public benefits available for older immigrants, tax responsibilities for immigrants, eligibility for Medicare and Medicaid, which we care about, Social Security, SSI, the Affordable Care Act, why become a citizen and the advantages of that, taxing money overseas, and estate planning for older immigrants. And some of these questions, agenda items, may seem like out of left field, but hold on for a second as we answer 10 questions that I think that our presentation will try to cover and try to answer. So I have like a list of 10 questions every elder law attorney should be aware of in their practice. So today's learning objectives are the following: public benefits for non-citizens, elder law, how elder law attorneys can help this demographic, pitfalls to avoid as an elder law attorney serving these populations, and questions to ask the client as they walk in. Let's go on to our overview of eligibility for public benefits, and these are basically for clients who are immigrants. So I included a slide of immigrants doing their, I guess, Tai Chi, or I'm not sure what it was, but it looked interesting to me. So here are my 10 questions. So these are the kinds of questions I want you to take away from this presentation, and hopefully we will answer these questions. And like I said before, one of the reasons that I got into this area was because I was an immigrant once upon a time. I became a citizen about 30 years ago, and my interests were immigration planning, immigration law, and I was also interested in estate planning. And then as my practice progressed, last couple of years ago, I started getting into elder law and was having a lot of older clients who were immigrants. And then suddenly some of these more complex questions started coming up about, are they qualified? What are they qualified for? How do I plan for them? And then as I started answering these questions for myself, I thought to myself, there may be some benefit to sharing this with others. And of course, Lynn Booth said, hey, you should share this with them. And so here I am today sharing this with you, and I'm so happy to do that. So let's talk about these 10 questions. What public benefits are available for older immigrants? Second one, how can I help my older immigrant clients and their families access available public benefits? Thirdly, what are the considerations for older immigrants when planning for their retirement years? What are the tax responsibilities of immigrants? We want to talk about this because this affects estate planning for them. Amongst immigrants, who is eligible for Medicare, Medicaid, Social Security, SSI, and the Affordable Care Act? And most of all, how quickly can they become eligible for these benefits? And what are the obligations of sponsoring relatives when petitioning for family members? So as an aside, what we have done is when Immigrants are now, we're qualifying immigrants. Some of them, we've started developing a roster of trusted vendors who may be able to provide insurance and mortgage benefits to these populations. And also other attorneys overseas who may be able to help them with their foreign estate planning as well. So other questions are, number 7, what are the consequences of making false claims for benefits? What are the advantages of becoming a U.S. citizen? Can estate planning mitigate some of these challenges faced by older immigrants? What are the estate planning issues faced by immigrants, and how can they be addressed? So, I mean, yeah, I mean, there's immigration law, I understand that, but as an, and I'm sure the question comes to your mind, how does this affect my practice? So one of the reasons I want to talk about this area is because foreign-born workers within the United States make up 17% of the workforce. That's about 26 million workers. And each of these people are probably on a path to becoming, getting a green card over here, that's becoming permanent residents, and then becoming citizens. And many of them want to have questions in this area. This is a hot topic. Many of them would want to bring their older relatives, especially aging parents, to live with them. A lot of immigrants live in extended families, and they want to continue that custom and culture. And when these parents come in, they have questions about access to health care and the other benefits that are relevant to their needs. Immigration law is the storm cloud that hangs over every foreign-born senior's eligibility for federal and state-funded programs. So at this point, we have a poll that Ashley will conduct, and please answer the poll. Thanks.
Yes, it looks like 56% answered yes, another 44% answered no, and we had about 60% of the attendees submit their answer.
Great. Thank you for answering that, because this is the issue, is that actually I'm so glad you said that, because immigrants are eligible for benefits like U.S. citizens only after they qualify under immigration law. And I'm so glad you answered that, because today that's our entire subject, is about how we qualify these people. So I'm very, very glad you answered it. So that's great. Let's go to the next slide. Ashley, I'm not able to advance it. Oh, there.
I click in on these.
Yes, I got it. Thank you. Whom are we talking about? So these, we talk about immigrants, whom are we talking about? So we're talking about 4 categories. Naturalized citizens. Now these people are people who come, born overseas, come, then qualify through immigration law, and they become citizens here after a certain number of years. And this population has the same rights, privileges, responsibilities, and eligibilities for all the benefits that U.S. citizens born within the United States experience and benefit. Then there's the other population that are immigrants. Now these people are not citizens yet. And these people are called green card holders. You must have heard that in the media. So green card holders, green card holders will generally qualify for many of the same benefits as citizens, but with some restrictions. And we'll talk about these restrictions. And this is the population we are most concerned with. People who are legal here in the United States, the government is allowed to stay here permanently, and they are entitled to benefits, but with caveats. The law is always about caveats. Then non-immigrants who are temporary workers, visitors, students, they have limited obligations and limited access to public benefits. Of course, the undocumented, about which the entire media is talking about, they have extremely limited access, and they're only available in certain circumstances. And one of the reasons I want to talk about these groups, the naturalized citizen and immigrants, is that naturalized citizens could still be married to a spouse who is not yet a citizen. So then you're planning for them for benefits for maybe the naturalized citizen or even the spouse under certain circumstances becomes much more complicated, because you need to think about when you are drafting a Medicaid Asset Protection Trust or a Veterans Asset Protection Trust, what does that trust look like and what do you need to include in those trusts? And so it may or may not work the way it would work if both spouses were U.S. citizens. So let's talk about benefit planning for the foreign bond. Generally, we are going to talk about U.S. citizens and permanent legal residents. It affects our elder law practice because this group of people have to first qualify for benefits only after the requirements of immigration law are satisfied. So they have to become satisfied under immigration law. Then they come and say, okay, now that we've satisfied the requirements of immigration law, then in addition, we have to satisfy the age, asset, income limitations imposed by federal, state, and local regulations. And so I like to think of it like the Cake Boss. Has anybody seen that TV show? It's like this. He makes this beautiful cakes, most yummy cake, chocolate cake, lemon cake, whatever, and then he puts this fondant on it. It's like he shapes it into all these flowers and cars and all the other stuff. And then I particularly don't like fondant, so I feel as if I have to go through the fondant, which in my mind is like immigration law, to get the cake, which are the benefits. So, you know, that's one of the ways in which I think of this entire subject. So let's talk about what we really want to talk about: Medicare and Medicaid and the Affordable Care Act and benefits that this population can obtain from those laws. Okay, first, Medicaid eligibility. In your handouts, there is an article from healthcare.gov. Now, I want to give you a heads up. There are a lot of federal websites that have excellent information, and I will be sharing with you in these handouts. I have shared them with you, and then if you go from time to time to these websites, especially if you have a client who is in one of these categories we are talking about, then you want to check their eligibility under immigration law before you say they're eligible for benefits, federal and state and local benefits. So when we are looking at Medicaid eligibility for older legal residents, and we're talking people who are not citizens yet, only qualified legal immigrants are eligible for Medicaid coverage after 5 years of residency. Of course, again, there are caveats, and we'll discuss that. Refugees, asylees, Cuban and Haitian entrants, trafficking victims, and veterans' families may be eligible earlier than 5 years. Undocumented immigrants are excluded from Medicaid and Medicare. They may be getting only emergency care. And this is a very important topic. Form I-864 has been filed with immigration applications. So I want to talk a little bit about that. So this affidavit of support is filed by a sponsor who's generally either a U.S. citizen or a green card holder who's getting their spouse or their parents, children, brothers and sisters to the United States. Now, everybody can't get all their relatives in. So if you're a U.S. citizen, you are filing for your spouse, your parents. They are the only people, the only U.S. citizens can bring their parents in. And in particular, we are talking about parents because they are the older generation. So for whom we are concerned with in elder law. So if I am bringing in my mom and dad, I have to file what is called an affidavit of support along with the application for their green card with immigration law, with immigration, USCIS. So when I do that, I'm basically telling the service, hey, I'm bringing my parents in. I will pay for all their health care for 5 years. At a minimum, and I will thereafter, the only way in which I can get out of this obligation to support them is to make sure that either they have 40 quarters, then my obligation is over. If they become U.S. citizens, my obligation is over. If they die, my obligation is over. If they give up their green card and move overseas, my obligation is over. If I'm sponsoring a spouse, my obligation is not over, even if we get divorced. So this is a very serious obligation, and the federal and local agencies, state agencies know about this, and it will be a factor in Medicaid applications. Now let's look at that handout. It's called, on the top it says healthcare.gov, and it talks about coverage for lawful permanent immigrants, so the lawful present immigrants, sorry. And the kinds of persons who are included are qualified non-citizen immigrant status without a waiting period. And there are some people who don't have to wait for these 5 years. And some of those people are asylees, refugees, Cuban, Haitians, people who have got green cards and who originally entered as asylees, refugees, battered women and other non-citizens who qualify under the Violence Against Women's Act that was passed during the Clinton era and has been renewed again. Those people are also federally recognized Indian tribes and American Indian born in Canada. So somebody is born overseas is also eligible. And the reason I say this is that, and one of the reasons I ask about this is that I had a client who came into my office and she looked like the grandma, my neighbor's grandma. And I'm like, at that time I was much more focused on immigration law, and I'm thinking, did you lose your way? Did you come into my office by mistake? And it turns out she didn't. She actually was born in Germany, and she thought she was a U.S. citizen, and she was not, because nobody filed any paperwork for her. Her parents did not file paperwork for her, although they were citizens. So this can happen, and I just wanted to talk about that. So what happens when one of the obligations you sign the sponsor signs when they file this form I-864 is to say that my relative whom I'm sponsoring will not become a public charge. So let's examine what a public charge is. So what is a public charge and why is it important? It's definitely important for Medicaid eligibility. Your local state agency knows all about the I-864, and that's one of the questions they will ask. Now, with this public charge, I've included another handout, and this handout comes from uscis.gov, and it's updated from time to time, and it's an extremely good site to visit for if you have a client who's an immigrant. So, public charge is basically assistance for subsistence. That means their basic, the immigrants is basing their entire life on this money given by the government, and it generally refers to cash assistance, but some other benefits may not be subject, such as CHIP and SNAP and housing benefits, child care, educational assistance, unemployment. So you have to be careful. But since we're talking about older group, they may not be in any of these particular programs. Let's look at the next slide, and I will talk about that also in a little more detail. Oh, by the way, food stamps are not part of this, are not a public charge. So if one of your clients is on food stamps, they're definitely not a public charge. And they are an immigrant. Those still qualify for Medicaid. So what is a public charge? It's a state-imposed charge for money that the recipient was legally obligated to pay. And then the government said, I had made a demand for payment, and the recipient did not pay. So this matter of V. And the test in this area is a test of the totality of circumstances. Now, you don't have to write any of this down because it's all in this handout that I've given you from USCIS. And on the very first page, you'll see some of the factors that are involved: age, health, family status, assets, resources, financial status, education, and skills. So just because a person is institutionalized doesn't necessarily, because of the mental disease, does not necessarily mean that this is a reason for deportation. And one of the reasons we do talk about this is because it is a deportable offense to become a public charge. And it could also render that person, if they have applied for a green card, it could render them ineligible for a green card. So having a Medicaid application and you suspect that they may be a public charge issue, this is a good place to go and do some research to find out if they are a public charge or not. Let's go to the next slide. So let's talk about Medicare and Medicare eligibility. Immigrants with less than 5 years of residency are not eligible. Of course, there are caveats again, and we will talk about that as well. There is also in the same handout that you look at, that we talked about, the healthcare.gov. There are some more details about who is not eligible. Now, so for such persons who are less than 5 years, they have to get their insurance through Obamacare. And we learned how to do this. We had a client who sponsored her mother, who was about, I think, 73 or 74 when she came in. And she came here, and of course the very first thing that everybody was concerned about is how are we going to pay for health care. And of course, as you know, since she's been here less than 5 years, she did not qualify for either Medicaid or Medicare. So Obamacare refused to, the healthcare exchanges refused to cover her until we got letters from both Medicare and Medicaid refusing to cover her, saying that she was ineligible for coverage. Then we went back to Obamacare, the healthcare exchanges, and she got qualified. In general, Medicare eligibility is 40 quarters of work to be eligible for Part A and not pay a premium. If the income of the recipient's income is less than 400% of the federal poverty guidelines, and the federal poverty guidelines are put out by the Health and Human Services Administration. And actually you can find it on uscis.gov as well, the federal poverty guidelines, in case you're interested. And the green card holder at that point is eligible for premium tax credit. So fortunately, this lady was able to, fell under that category, and she was able to avail of some tax credits for her premiums. Now let's talk about Social Security and immigrants' eligibility for Social Security. There is a handout with this. It's called Spotlight. It says Social Security in the top and says Spotlight on Social Security benefits for aliens. Now, when I say aliens, they're not from Mars. They're regular people here, and you know, and that helps. So the Social Security eligibility is in order to be eligible at the very first instance, they need a Social Security number. So when a non-citizen makes an immigration application and they're eligible for Social Security, then the part of that, as part of that application, you check off a box that says immigration can share the fact that they are becoming legal permanent residents in this country with the Social Security Administration. So the Social Security Administration is warned in advance of your eligibility. But you have to make an affirmative application by going into the office and actually asking for a Social Security number along with proof of immigration status. Some people are also apply for what is called an ITIN number, which is an individual tax identification number that is required. You may need to file a U.S. tax return. And depending on the time of year, it can take about 4 to 5 weeks to 6 months to get the number, depending on how swamped the IRS is at that time. So eligibility for Social Security is the same for all workers, regardless of immigration status. They have to have 40 quarters, that's 10 years of earnings, in order to be eligible. Now, if you're not if you're not a green card holder, that means you're in some other status. Even if you have the 40 quarters, you're not eligible to receive Social Security. You have to be a legal permanent resident or a U.S. citizen in order to be eligible for Social Security. In 2017, each quarter's earning was $1,300 for each credit. So SSI is available to immigrants only after 5 years, again with caveats, and again you need their immigration status. So let's go to this handout to see who is qualified, who is a qualified alien, who the alien means not a U.S. citizen, who was eligible for this for SSI. So if you are in one of the categories, you enter your green card and you've entered as an Amerasian immigrant, you have conditional entry into the United States under the immigration law. You have other terms of art are like paroled in the United States. If you're a refugee or asylee and come to the United States, deportation has been withheld under certain sections of immigration law. A Cuban or Haitian entrant, and all these people are qualified aliens, and they could be eligible for SSI depending on certain requirements. In fact, they could be eligible for SSI even if they themselves have don't have 40 quarters, but there is a parent or a spouse who has got the 40 quarters, so that they can get SSI. And there are more qualifications under this, including certain persons who are on active duty and they are honorably discharged. So they may also be eligible. So among your veterans population, please look at those non-citizens' eligibility as well. There are additional categories who are eligible, and of course they need to have need to prove immigrant status. But as usual, if there's an I-864 filed for you, you may mean for the client, they may not be eligible at all. Now, let's go to the next slide. I want to talk a different aspect of Social Security eligibility, and this is based on totalization agreements between two countries. So now we're talking about foreign citizens where their country, the U.S. and their country has come to an agreement between both the countries saying that we will eliminate dual taxation for Medicare and Social Security. So if the foreign citizen is working in the United States, they'll either just pay the U.S. taxes or the foreign taxes, and generally they pay the U.S. taxes for Medicare and Social Security. And they may or may not be a citizen of the United States, but they're definitely in lawful status, so they continue to earn the 40 quarters. One of the reasons I came into this area, as I was telling Ashley about it, was that one of our clients was employing a worker from Canada, and the Canadians. He came here on what is called a NAFTA. There's a treaty between Canada, the United States, and Mexico called NAFTA, which is much in the news right now. And under this treaty, there's a special visa category for people with certain qualifications from these countries that can work in the United States under a visa called TN visa. Now, these people on TN visas can pay FICA taxes, I mean, it's the Medicare and Social Security taxes here within the United States, and still maintain 40 quarters in Canada. Mexico is not eligible because Mexico is not one of those countries with which the U.S. has a totalization agreement. So they are eligible. So this gentleman needed 2 years to complete his 40 quarters in Canada, so he came to work in the U.S. and obtained his 40 quarters. And that's how we learned about totalization agreements. Then I had another client who was from Spain, working here in a big corporation here in the United States. She wanted to maintain the option of either retiring in the United States or in Spain, and so Spain and the United States have a totalization agreement. So under this, she pays the FICA tax, the Medicare and Social Security taxes here, to be more particular, and she has earned her 40 quarters. But if she wanted to live permanently in Spain, she had to maintain a U.S. status in case she wanted to come back to the United States. Now, you lose your legal permanent resident status, that's the green card status. You can lose it if you go and live overseas permanently. So in order to preserve her status within the United States, she had to become a U.S. citizen. Now, immigration law, I told you it was the fondant on the cake. So guess what? Now, Spain has their own immigration law, so we had to then comply with Spanish immigration law that says if you become a foreign citizen, you have to come back and reaffirm your Spanish citizenship. So that's what we are doing for her now. We are reaffirming her Spanish citizenship so she can have the option of retiring in both countries and option of drawing Social Security either in Spain or over here. It's kind of interesting where the path leads you. So, so what are the kinds of questions we want to ask? Oh, before I do that, I want to go back to the prior slide. I wanted to talk about the I just want to list out the 25 countries that are with whom the United States has totalization agreements. And you can find these totalization agreements on the Social Security Administration website. And if you just Google it, you should get it. It's also on the IRS website, but not the actual agreements. The actual agreements are on the Social Security website. So let's see. Here are 25 countries in alphabetical order. Australia, Austria, Belgium, Canada, Chile, Czech Republic, Denmark, Finland, France, Germany, Greece, Hungary, Ireland, Italy, Japan, Luxembourg, Netherlands, Norway, Poland, Portugal, Slovak Republic, South Korea, Spain, Sweden, Switzerland, and the United Kingdom. Some of which some countries you expect, and some countries that are slightly unexpected. Now let's go on to the next slide. So so now I've kind of modified my intake. Now that I know all this, I've modified my intake. So one of my questions on my intakes asks, are you a U.S. citizen? But I don't stop there. Also ask them, do you have 40 quarters of work credits? Is there an affidavit of support filed for you by a sponsor? I also ask them one more question. If they are not a U.S. citizen and they are a permanent resident, how they received their permanent residency. So because, as I told you before, just because you're a permanent resident or green card holder, don't always have this affidavit of support filed for you. Now, that is only filed by your family. Now, if you're coming as a refugee, as a asylee, you're an American Indian born in Canada, or you come from Cuba, Haitian Refugee Act, those kinds of entries, those people are eligible before 5 years. So that further inquiry needs to be made if they are here on a green card. So the other question we also need to ask is, do you have a pension or retirement paid to you in your home country? And I will tell you a story about this, because this could become an available asset and could be considered income and may render the client ineligible for Social Security and or Medicaid. The last question you want to also inquire and is I mean, the client may not know, it's your inquiry. Is there a totalization agreement within the U.S. and that home country of your client? Sometimes, if they are a U.S. citizen, this inquiry may be needed as well, especially if they have worked overseas. And it's one of those 25 listed countries. And that's the reason I wanted to list those countries out for you. If you want a list of those countries and you want that that handout, I don't know if I provided it or not, I will be happy to provide that. So I had a client in California. Gentleman was 92 years old. His son called me and said he was referred through somebody. I, by the way, don't have a California license, so I'm only licensed in Missouri and Illinois. So but this was federal law, so I said I will talk to them. And they told me that his father had received a demand from Social Security to repay $18,000, and he didn't know what to do. And on further inquiry, what we discovered was the father had been a doctor overseas, and he worked for the government. And so he had a very small government pension. Now, further facts in the case, he was 92 and he was legally blind, and so he had been receiving Social Security disability for a while, and so now the government is coming back and saying, hey, you are not eligible for this income because you have a pension from overseas which you did not declare, so now you need to pay back $18,000. So that's what we learned, that sometimes clients have these pensions from overseas or some assets from overseas that they neglect to disclose, and so this also could become factors in making Medicaid applications and Medicare on other Social Security applications for these elderly immigrants who are here either as U.S. citizens or as permanent residents. Fortunately, since he lives in California, he still had Medicaid through California, but generally everybody else may or may not be quite as lucky as that. So let's talk about taxation of an immigrant's liability under the U.S. tax regime. Everybody has to declare overseas income, especially if you're a U.S. citizen or you are a legal permanent resident and you get income from overseas. You have to file it with your tax return. Actually, the declaration has to be done by the 30th of June, and if the foreign income is over $10,000, it has to be declared on Schedule B and Form 8938. And they also citizens and legal permanent residents who have foreign assets also are subject to estate and gift tax on those worldwide assets. Non-U.S. assets and income are available assets. Non-residents are taxed on U.S. derived income. And I have a handout with this that talks about IRS reminding those with foreign assets of their U.S. tax obligations. So these tax obligations also come into effect if somebody is receiving money from overseas as a gift. And the reason I want to talk to you about that is about special needs trusts, and especially special needs trust in the context of third-party trusts. I have a client whose foundation, and they have a support group for special needs. These are for parents of special needs children, and all these special needs children are from a particular country. And so this support group is both for the parents and the children, for cultural acclimatization and to support parents from a certain cultural background. So, and you know, when I made this last presentation to them, I discovered very, very interesting things, that lots of them don't have any conversations with their overseas grandparents of these children, and they've stopped making visits back to see grandparents and family just because they are a little ashamed of the fact that they have, or maybe the parents are not so ashamed. I think I'm not saying that correct. I think they feel that they are somehow their family looks down upon them because of this. And so this was just a cultural nuance I wanted to bring out there, because this may be an issue in other cultures as well. If such groups if such families get overseas gifts for over $100,000, then they need to file a Form 3520. Taxes may not be paid, but it's definitely IRS wants to know that you're receiving overseas gifts. So another issue with special needs trusts is that, how do you choose a trustee? Very often immigrants here don't have, family here within the United States who are U.S. citizens. So if you choose a foreign citizen trustee, then it becomes there are many more reporting obligations on the IRS, and I tell them to steer away from that because people may forget to report. Sometimes they don't, since they don't have anybody as to name as trustee, I always tell them, please, maybe the people within the group can be trustees for each other. That may be a consideration they want to have, but I had to keep in mind that within the group, all parents were not U.S. citizens. Some were non-citizens, some were not yet citizens, some were on visas, but all the commonality among all of them was they had this special needs child. Oh, I tell them, please go get friends. Make sure the friends are U.S. citizens. You know, it seems kind of sad to say that, but that's, I think we need a bigger community, as Hillary Clinton says, it takes a village to bring up a child. Okay, let's talk about the next topic. I think I'm slightly running into time issues, estate planning. There is a handout, no, there's no handout on this, sorry. So it's for non-citizens, especially mixed couples, it's a problem. Estate planning, and especially doing MAPs and BAPs and any special needs trusts, all these become issues because there are different, there is no unlimited marital deduction. Then there is a lifetime gift tax exclusion to a non-citizen spouse is only $149,000. Now you don't have the uniform 5.4 million. So in order to get this unlimited marital deduction, you have to use a very specialized trust called the QDOT, Qualified Domestic Trust. A lot of information is available about it both online at the ABA and also from Wealth Council, I think, and then also from the IRS website. So you have to have this. The QDOT is a bit like a Q-tip in the sense that only the income has to be distributed to the non-citizen spouse every year. If the estate is larger than $2 million, then you have to have a U.S. bank also as a trustee. An individual can no longer be a trustee now, and the trustee has to be a U.S. citizen. So also that if the it's an individual who's serving as a trustee of an estate over $2 million, then you are looking at posting a very big bond that is up to the value of 65% of the total amount of the estate, of the value of the estate. So what is the solution to this? So I tell them, please, if you're a non-citizen, become a citizen so that these are not issues for you. So if I come, for instance, remember I was talking, I had this mixed couple who came in from Canada. Well, she was Canadian and he was U.S. citizen, and I discovered that in their intake. And for them, I had to include a QDOT in their estate planning, or at least mention that they could qualify for a QDOT so that they can elect to have a QDOT even after the U.S. citizen spouse dies. This all complicates, again, Medicaid asset planning, veterans asset planning, special needs trust. It complicates everything. So what are our takeaway lessons? What do I want to learn today? Tailor your intake. Don't presume everybody is a U.S. citizen. Non-immigrant visa holders or green card holders are only eligible for limited benefits within 5 years. And so check your state, check the federal law. Ask immigrant clients if there's a pension overseas. Look for totalization agreements. Look for an I-864. Oh, by the way, all these rules apply to same-sex couples as well. Thank you very much. I think I'm out of time. And Ashley, back to you.
Thank you, Malini, for your presentation on a very complex topic. That was wonderful. We are running a little short on time, so I'm going to skip those upcoming events. And I'm a little surprised to report that we don't have any questions. So, Malini, you're off the hook today.
It's okay.
You're off the hook. Thank you, everyone, for attending and participating in our poll question. Please provide us with your feedback by completing the survey And on behalf of Elder Council, we look forward to seeing everyone next time.
Thank
Have a
you.
great day, guys.
Thank you. Bye-bye.